Hello, everyone. I'm a little late for the live stream. I apologize. Hello. Thank you for telling me about your cat. Cats do love to disrupt computing activity. There's no question. We have a question here already from YouTube user Shiz, S-H-I-Z, who says, I am a federal employee. What is the cost for litigating EEO cases all the way to a hearing? Also, I know different attorneys have different rates. What is a reasonable or average hourly rate? So, Shiz, I would say if you're paying hourly for federal employee EEO representation, you will very rapidly go bankrupt. That is very expensive. Let me turn on my lights here. For some reason, my lights are not on. There we go. Okay. Whoa. All right. You'll go bankrupt pretty quick because federal EEO representation for federal employees is incredibly time consuming. I can tell you that I know a lot of firms will charge a flat rate up front, and that often ranges from $20,000 to $40,000. And then if they win you money, I think they might give you back the $20,000 to $40,000 that you paid up front and take their percentage instead. But that is expensive, right? That is, to my mind, however, a fantastic deal compared to paying hourly for federal employee representation at the EEO level. There's still, I think, a couple of firms in the nation that might do federal employee pure contingency, but I can't find them. I've been trying to find them for people for a while. And we represent federal employees, but it's not pure contingency. So I've been looking for those firms to send people to. It's hard. I hope that answers your question, Shiz. Be me, YouTube user Be Me says, what is the process of admissions and are they useful? Not really. I mean, it depends jurisdiction to jurisdiction. Things are handled a little differently, but the rest of your question is, do employers tend to answer them falsely? Only if they think they can get away with it. And generally, the attorneys would not try to answer it falsely. They would try to answer it accurately, but sometimes the employer will lie to defense counsel, and then defense counsel will, print their lies on accident. YouTube user Sean S. says, will defense counsel try to force it to go federal? So I assume you're talking about workplace discrimination, workplace sexual harassment case. Generally speaking, defense counsel is trying to keep it from going to federal court. They're trying to keep it within the EEOC or a state agency if they can. They want to get the case settled without it going to federal court. Defending a case at the federal court level is way more expensive. So generally, defense counsel, if they're trying to get a good deal for their client, will try to resolve cases or keep them out of federal litigation. My story is still being written, says, great to see you again, V. Good to see you. I received my right to sue letter today. Question, how many employees turn a case into class action? There are 4 other employees with EEOC cases against the same employer. So listen, I have videos on class actions, and everybody, it's very common for folks to try to get a class action started. The reality of the situation is, though, that rarely happens. 4 people is almost certainly not enough. And if you did achieve a class action, you probably would get pennies on the dollar. Class actions are amazing for making attorneys money, but they are horrible for making plaintiffs money. It's just not at all useful. YouTube user Yo Cannon says, can I speak publicly about arbitration cases if I don't sign an NDA, or are NDA agreements already part of AAA arbitration? Listen, I don't know. So AAA arbitration doesn't set your arbitration agreement, for the record. So here's how it works. And I just full disclosure, I sit as an arbitrator for the American Arbitration Association, which I believe is the largest arbitration association in the country. I also think they are the largest. I think they're in more employment agreements than anybody else in terms of if there's a set arbitration agency in an employment agreement. But the American Arbitration Association does not draft your employment agreement. They're just an arbitration service, right? You can choose to hire them, and they will help you to hold an arbitration and assign an arbitrator and make all these things happen. But they're not the ones drafting your arbitration agreement. The arbitration agreement is between you and the employer. Presumably, drafted by the employer and agreed to by you. So when you ask me, like, is there an NDA agreement? I don't know. I haven't read your arbitration agreement or your employment agreement, so I don't know. YouTube user Staka Khan says, what's the next step after investigation is concluded and the case is found? Well, it depends on what agency you're in. Generally speaking, so like if you're in the EEOC, I mean, they're probably not finding merit necessarily. They're probably just issuing a right to sue letter. So the next step would be filing in federal court. If you're like in the State Division of Human Rights in New York and you get a for-cause finding, which is basically a finding of merit, a hearing follows in that agency. Several conferences with, administrative law judges, and then eventually a hearing. YouTube user Ramona Hudson, can you explain what the bottom line number for mediation settlement talks? Ramona, so I don't fully understand the question. Your question is, can you explain what the bottom line number for a mediation settlement talks? I don't understand, but I want to understand. And I want to answer. We got 25 people concurrently at 2 p.m. on Thursday? All right. We need more questions. Ramona, we got a question from Amy. How do I enjoin an employer to a case? I have something filed against a vendor, and I would like to enjoin their employer because I believe they are responsible for the vendor's actions. You would make a motion. I mean, listen, it's going to be the process is going to be different in every jurisdiction. So I can't tell you how to do it in your jurisdiction, but yeah, you generally speaking, in most of the country, make a motion to add a party to your litigation. That you're adding a defendant. YouTube user Tiffany says, "Hi Vince, nice to catch you on live. Nice to be here." And Tiffany has a question, and we don't have it yet. Keach Alp says, "Outside work, how do you be productive?" I'm like an odd person in that I don't get tired. Like I get physically tired, like my body, like if I go lifting or like go running, go play tennis, whatever, go ski all day. Obviously I'll feel physically tired, but like my brain doesn't ever really get fatigued. So I don't know that I have an issue being productive. Like I fill my day with like, I farm, and stuff like that and try to like work out and, try to stay busy. So I don't know that I have difficulties being productive. I just don't have that many like things that I like doing. So I don't get distracted that much. I always wonder how people fill their day, which is a strange thing to say. Like people are like, "Oh my God, I've got to work a 60-hour work week." And I'm like, well, if you worked less than that, like what would you do all day? I don't understand. Ramona Hudson's question is, excuse me. My attorney asked me what my bottom line number is ahead of the mediation. Okay. So Ramona, they want to know where you want to end up. What's the minimum you would accept? That's what they're asking for. Jerome Etheridge says, can my temp agency and the company I work for both be held liable for discrimination? Depending on the jurisdiction and what happened, yes. Masked Mentor says, in the last live, my question was misinterpreted. I wanted to be an attorney, but no longer wish to attend law school. With my audit background and MBA, can I become a mediator without a law degree? Yes, you do not need a law degree in any jurisdiction that I'm aware of to work as a mediator. I will say, without the law degree, many attorneys may not choose to hire you. But if you build up a practice and you're able to convince attorneys to hire you, you are certainly legally allowed. My story is still being, to the best of my knowledge, Masked Mentor, you are legally allowed in most jurisdictions. Check with local counsel. My story is still being written. Asked question. Once your case is filed in federal court, is it true all public access records at that point? Yes. Federal court is generally going to be publicly available. It's even going to show up on Google. C note 1906 says, my counsel has filed in federal court in California, racial discrimination, retaliation. Counsel valued the case at $595,000. Not happy, but I agreed. On average, how much might I have to come down? I mean, that really depends if you want a settlement or not. So listen, I don't know anything about your case. There's not really an on average because every case is different. I also don't really know how your counsel valued your case, right? Like if that 595K is what your counsel thinks you can win at trial, then the reality is like it comes down to risk. Like, well, if you run that case 10 times, how many times do you think you're going to win? Half the time. So then you're going to maybe, if you want a settlement, come down potentially halfway. Just, as a and none of this is absolute, but it's a way of thinking about it, right? You're hedging for risk. Sean S says, is it helpful to a case when you have chronologically detailed emails? Yes, incredibly so. Incredibly valuable. Can't stress enough, Sean S. That is great evidence if it shows what you hope it shows. Yo Cannon, what would happen if you're already filed an arbitration, but you're able to invalidate your arbitration agreement through small claims court? I don't know that small claims court would have the authority to invalidate an arbitration agreement, but if for some reason or somehow they did, in whatever jurisdiction you're in, you could theoretically pull out of arbitration and file in a different court. Me says, how do I enjoin an employer to a case? Okay. Yeah, I can't give you advice. I'm not a workers' comp attorney, so you need to speak to a workers' comp attorney in California. That is the only person who will be allowed to give you that advice. But even further, like I'm not a workers' comp attorney, so like, and I don't practice state workers' comp work in California, so I just simply don't know that answer. The Head says, how long do judges take to rule on a motion for summary judgment? I mean, listen, 3 to 14 months, realistically speaking, is fairly common. It's been almost 4 months now since my reply brief was entered. I don't mind the long time because case law would be popping up on the topic. Yeah, that makes sense. Sounds about right. Ramona Hudson, will the other attorneys know this? Will the other attorneys know my bottom line number, or is that between my counsel and I? So Ramona, if you trust your attorney and you tell your attorney to keep your bottom line number secret, then it should just be between you and your attorney. Now, there are definitely some attorneys who might ask for your bottom line and then just tell opposing counsel, this is the bottom line if you want to get this done today. I don't think that's a great tactic. I think it's also dishonest to your client, especially if the client wasn't aware that you were going to do that, right? That's not great. It does tend to get, I definitely see people do that and it can get cases settled, but I think it undercuts the client, undercuts the case value, and it's just kind of a stupid and dishonest tactic in my mind. DFS 21, what reasons would render the EEOC selecting a case for early mediation? Both parties agree to mediation. That's it. Yeah, so the EEOC just tries to mediate whatever it can, and if both parties agree to mediation, then you go to mediation. K Levy 26 says, my retained attorney did not seem very interested in false promises claims. Yeah, I'm already not interested. Is this common? Can we bring up potential false promises lawsuit during mediation as a way to gain leverage? Listen, I'm not saying you don't have a false promises case. You may not. Different jurisdictions have different elements for that. Certainly. So like, listen, those claims can exist. They can be valid. Generally, those claims are garbage. And I wouldn't, like, if you were in my office talking about false claims, I would probably be like, listen, that's great. We don't want it. You can take that somewhere else. We only want the discrimination, the sexual harassment case. That's the case we view to be, low risk and high value. And listen, we've definitely brought, breach of implied contract stuff and, some false promises. Like, it's a tactic we use from time to time where it's appropriate, but it's very situational, very context dependent. And like 99 out of 100 of the clients who are like, but false promises, like, you're like, okay, you got to go. Like, this is nonsense. This doesn't make any sense. It's not just, and I'm not saying this is true for you, Kayla, Levi. I have no idea, right? I'm just saying that most of the time, most of the people talking about those claims are just like trying to hurt themselves and their claims. My story is still being written says, is it okay to still collect witness statements from current employees still within the company, or shall you let your attorney who is representing you do this? Can the plaintiff help too much sometimes? Yeah, you definitely want to let your attorney do that because there's definitely a way to do it wrong, right? Like if you're making people promises in return for testimony, that's going to invalidate the testimony. If you go about it the wrong way, it can undercut the testimony. So like, have your attorney do it. No question. All right. B. Me says, will defense always file for summary judgment regardless of discovery, depositions, etc.? No. I've definitely seen cases where defense did not file for summary judgment. It's cases where there's not really any question, that there's a question of fact that needs to go before a fact finder, so the judge, the jury, whoever, the arbitrator, whoever it might be. Also, you'll see summary judgment motions where only like one or two of the claims in the case are actually being sought for summary judgment, and the rest just are left untouched. So it's very common that not all claims would be subject to summary judgment motions, or that there might not even be a motion. Sammy Rumble says, if the employer's counsel requests a demand letter, does that mean they are going to settle? No, but it does mean they might be interested in settlement, right? Listen, if they say, I'd like a demand letter, and in their mind they're thinking, I would pay 50 grand in this case, and then you like send a demand letter and you're like, I want $500 million, they're going to be like, oh, okay, time waster, let's litigate, right? So no, it doesn't mean it's going to settle, but it does mean they're open to the conversation, and that's probably a good thing. Lofty with an I says, my state agency says that the investigation will take 2 to 3 years. Is this normal? No, that is not normal, but it could be normal for your state agency. There are some state agencies where things take much, much longer. Generally speaking, I'll tell you, even in the cases that we have that are in state agencies, which, are somewhat rare at this point, we're looking to generally like close out 95% of those in about 9 months. Just realistically, that's how long they take. So I would say that, 2-3 years for a state agency investigation sounds wild to me, but there are states where that could be the reality. Ramon Hudson says, thanks, Vince, aka Batman. I wish I was Batman. I'd be so cool, but I would want to be like Christian Bale Batman. I don't want to be any of these other crappy Batmans. And I am no Christian Bale, let's be honest. Unbeknownst guy says, if defense counsel made a position statement saying an instance admitting to 2 events that were positioned by plaintiff's actual events. If defense counsel made a position statement, say an instance admitting to 2 events that were positioned by plaintiff's actual events, is it wise to try those claims in court? So I'm going to assume that what you're saying is that there's something in the position statement that supports your version of events for 2 events. And so that's good. That strengthens your position. Whether or not it's good to try them in court, I don't know. I don't know how helpful they are. I don't know how helpful the position statement is to prove those things happen. I don't know what they're offering you in settlement. And I don't know the strengths of your claim. So I can't say if they should, listen, is it helpful if the defense counsel supported your position, your narrative in the position statement? Yes, generally speaking. Does that mean you should try the claims? I have no idea. Okay, so Amy is asking, I think, about adding parties. And there's some stuff about the workers' comp board in California, which I'm just going to leave out because I don't deal with that. But I think there's also a question about the EEOC. And with the EEOC, you can just amend your charge or file an additional charge, right? So if you want to add a defendant, I guess a respondent, to the EEOC, you can just amend your charge to add that respondent, or you can just file an additional EEOC case against the additional respondent and run both of them in tandem. Kelsey, YouTube user Kelsey says, why are some employment lawsuit settlements publicized in the media when others are completely confidential? Okay, so Kelsey, there's 2 things going on here. One, a lot of the settlements you're seeing that are publicized are actually verdicts. A lot of them are actually verdicts that have, gone to trial or some kind of public arbitration or hearing, and so they can be out there. A lot of those numbers don't ever get collected. A lot of times judges will actually knock those down. There's also settlements that take place where one party won't agree to confidentiality. So those can then be publicized. Or there's settlements that take place in like California where there's some difficulty. They're still trying to figure out a way around one of California's laws so they can settle cases confidentially again, which is kind of what happened in New York and New Jersey a little bit. Like New York and New Jersey made laws that like theoretically made it difficult to settle cases confidentially in this field. but they were structured with like back doors in them, so they could still be settled confidentially, and so they still are. So that's why you're seeing like those are the three reasons why you might see a case publicly available instead of confidential. Sonia Underwood says, I want you to represent me. Sonia, love to, by all means. Christopher Charles, I wish more employment lawyers were like you. If it's a little work involved, I get we might not be the right employment firm for you, and they give me numbers for other employment firms. Yeah, I mean, listen, I don't love the state of our industry. I'll be honest. Like, I think that there's not enough employment attorneys. Just off the bat, there's not enough employment attorneys. So that makes the employment attorneys that are out there a little bit lazy, and they want easy money because there's lots of cases floating around. There's a lot of cases that walk in the door. You're like, oh, okay, I'm going to settle this for like 300, 500, whatever it is in 2-3 months. And it's just easy money, right? They know they're going to get a couple $100,000 on the case. And so they don't take cases that take more work. Unbeknownst guy says it's racial harassment and sexual harassment, which I included gender harassment, sexual harassment, and retaliation. Those are the claims based on the position statement. Cool. Sonia Underwood, why do attorneys and judges dislike pro se? Because pro se litigants are super difficult to work with and generally don't know what they're doing. And it is like, it takes tons of extra hours to explain everything to them, but it's also really hard because they like don't know what you're saying. So they think you're misleading that. It's super difficult to have a trial with a pro se litigant. And also like pro se litigants don't really understand what they're doing 99 times out of 100. So it can be super hard. Kelsey says, thanks for answering my question. My pleasure, Kelsey. Truly. Shiz says, I want you to represent me, but you're not taking DOD employees. I'm sorry, Shiz. I apologize. Department of Defense can be tough. Fun story. I did not pass a background check to work for the Department of Defense. Thanks to my family, which I didn't even know was legal. But when your whole family goes to federal prison, I don't know. I guess things are a little different. I didn't, for the record. I didn't go to federal prison. Oh, thank you very much, Unbeknownst Guy. I really appreciate that. Oh, that's really nice. So Unbeknownst Guy says, you are a blessing, Mr. White. May God grant you an apprentice to continue this legacy. So I was actually like talking to two, I wouldn't call them apprentices, but an old protege of mine who's gone on to really successful things, trying to get her to come back to the biz. She's gone on to huge things. She's a general counsel of like a huge, corporate entity now, and she's really killing it. And it's just tough. It's tough to like really killing it. And it's just tough. It's tough to like push people to come back to have to win their money when they're getting like guaranteed money and their life is easier. And like, so that's hard. So I was trying to get her to come back. And I was also talking to another person who kind of works in-house, who I could see being like the future of my firm a little bit. But it's just hard. It's hard. And not everybody is fit for this business. This is a hard, it can be a hard business. It's been very good to me. Don't get me wrong, but like, there's a number of things wrong with me. YouTube user your canon says, theoretically, if I got my arbitration agreement invalidated while actively in arbitration, would I be able to open a new case without being outside of my right to sue window if I drop the arbitration? Oh, be very careful. Be very, very careful. If you have an open action and your right to sue letter is outside its window, I would be very afraid of your ability to bring a federal litigation now that your right to sue letter has expired. That would concern me greatly for you, Buchanan. So that's going to be a topic you would have to do heavy legal research on, but listen, I'll tell you flat out. If you came to me and you're like, I want to pull out of arbitration and file this new federal litigation, even though my right to sue letter is expired, I just say, nope, can't hire us. That's how little success I think that might have. Of course, do the legal research. Don't take my off the top of my head thought on that. Amy says, re-enjoining employer, I can only have one open charge in the EEOC in California, so I have to settle with one employer. Does that mean I have to? So if I have settled with one employer, does that mean I have settled in total? Well, so who you're settling with depends on who the settlement agreement is with and what the releases say. So I can't tell you who you're settling with because I'm not looking at the settlement agreement that you're potentially signing. That being said, it is not true that you can only have one open charge in the EEOC in California. They cannot limit you in that way. The EEOC does not have the power to limit you from opening additional charges. I will tell you right now, and I will further tell you that I know for a fact because I know people who have had more than one EEOC charge open in the state of California. So someone is talking some bullshit to you. Sonia Underwood, thanks for answering my questions. My pleasure, Sonia. Absolutely, anytime. Buchanan says, my case can be brought under Section 1981 that has no need of a right to sue. It can, yeah. 1981 is not necessarily going to be as advantageous as your other claims that pended through the EEOC. You certainly want to bring all your claims, the claims that pended through the EEOC in 1981, if it's legitimate. I'm just telling you that throwing away your EEOC claims because you want to get out of arbitration and just going on 1981 is not usually a good idea unless there's something very concerning about the arbitration. Christopher Davis, first off, you are the real deal. Thank you. I'm like the mediocre deal, but thank you. It's very kind. My issue is that I work remote, so it's been a complicated process finding which state I could actually file a suit in. In Tennessee, we don't have many attorneys who can help. So I was actually talking about this with somebody the other day. So I recently found 2 employment attorneys in Tennessee, and they were hard to find. Now, I'm not allowed to vouch for them or anything like that, but I can tell you that I found 2 in Tennessee who do the work and appear to do it well. That being said, they do seem a little bit overwhelmed. So, I mean, listen, if you're in Tennessee and you don't like the few employment attorneys that you have at your disposal, then yeah, talk to the national firms. Gloria Allred, maybe Morgan & Moore. I'm not suggesting anyone. And sure, I'm not vouching for anyone or suggesting anyone at all. I'm not saying anything about the quality of any of these firms. I'm just saying there are national firms out there in addition to our own that might help you in Tennessee. Shiz, do you know of any good law firms that represent Department of Defense employees? I actually, you know what? Try Jonathan Bell, law office of Jonathan Bell in Long Island. They might do DoD employees. 22J Dog, and sure, I think Jonathan Bell is a hell of a guy. He's a good human being, but I can't vouch for his law firm because I'm not allowed to. And the only reason I'm not vouching for his law firm is because I'm not allowed to. My malpractice insurance carrier gets very angry if I vouch for other law firms. I don't know. I knew Jonathan Bell when I was a very young attorney. He's a very talented fella. It's a very good office. A lot of good attorneys there. 22J Dog, what is your opinion on the NRP U.S. Postal Service class action done by Thomas and Sullivan out of New York? No opinion. Not familiar. Sean S. Events that are supported by documentation, I expect will be challenged by events that are supported by documentation, I expect will be challenged by defense, obviously. Should I expect them to lie? Yes, I typed lie in order to diminish their client's liability. So defense counsel probably wouldn't lie, but defense counsel will often be lied to and then convey lies. Defense counsel doesn't care enough to lie and wouldn't knowingly lie because it can generally imperil their law license, and that's not good for them. But if they don't know they're lying, they certainly can. Christopher Davis, I'm wanting to file a lawsuit against my employer for workplace intimidation, negligence, reputational harm, emotional distress involving racial comments made from a hostile workplace environment. Yeah, I would file the racial discrimination case. So everything you're describing is things that could be motivated by the racial discrimination that you're experiencing as evidenced by the racial comments. And that racial discrimination case would be potentially way more valuable than most of the claims that you're mentioning there. Harlem World Baby says, what about Section 1981? What about it? It's a useful law in certain situations, and you often want to include it where it's appropriate. Do you have specific questions? Christopher Davis, since the actions involve leaders within the company, I'm fearful of wrongful termination and further actions of retaliation. That's real. Listen, that's absolutely real. But if you document everything, the retaliation claims could increase the value of your case. And you can also potentially document everything really well so you're protected from retaliation. YouTube user Kelsey says, is a case at risk if the plaintiff never responded to defendant's position statement, but received a right to sue and filed lawsuit months ago? No, I don't. I would not be particularly bothered that a pro se plaintiff did not respond to a position statement. I wouldn't even be bothered if a represented plaintiff did not respond to a position statement, although I'd want to know why the attorney didn't, right? Like there's good reasons why you might not. If you get a position statement, you're like, oh yeah, we're well situated here. Let's just go to Fed Lit. Let's go to federal litigation. There's not really a reason to file a rebuttal anymore. You just pull your right to sue letter, right? Christopher Davis says, can your firm possibly assist me? I have no idea, Christopher, but you're welcome to contact our intake people. I do not do intake personally, and I certainly don't do it in live streams. It is something where you go through a couple layers of experienced professionals, seeing if it's a case that they want to assign attorney time to, and then you eventually talk to an attorney here, and the attorneys will extend you an offer or not. So in terms of would they talk to you? Absolutely. Would they extend you an offer? I have no idea. I'm sorry. Yocanan says, can I stay in arbitration while also filing my 1981 claim in federal court, or is this not possible? So Yocanan, the consideration there, the concern is that you're litigating largely the same events, right? If you have the EEOC case, and that's in arbitration, and you have the 1981 case, and that's in federal court, but they both deal with substantially the same events, that could cause complexity and issues and motion practice. People might seek to end one of those litigations or arbitrations. They might seek to combine them. There's a lot of things that might go on there. K Levi 26. What's the best rebuttal if employer claims they were unaware of the plaintiff's disability at mediation? Can lack of documentation around this tank the case? Yes. So the best, so if the employer says, hey, we weren't aware of your disability, the best rebuttal is, here's proof. Here's some evidence that you were aware of my disability. The best evidence would be like, hey, I sent you an email, timestamped by Google, on their server, notifying you that I have this disability, and you responded. Great evidence. Tremendous rebuttal. My story is still being written, says 90 days started yesterday. So I think you're probably referring to 90-day statute of limitations for a right to sue letter. What is the average time to write the case and file in federal court? If writing the case is the correct term. Yeah, so in terms of drafting a complaint and getting it filed in federal court, I would think it's very common for an associate working with a client to take about 2 weeks to do that. And then I'd want the partners at the firm to like review it a few times. So like 3 or 4 weeks would be ideal. Certainly, and listen, can it be done in 8 hours? Yeah. If I assign enough attorneys to it, sure. But, and if we have access to the plaintiff and the EEOC is well drafted, yeah, listen, I'll be frank with you. I think I've taken a case early in my career, probably somebody walked in the door on the last day, and I'm sure we probably got something filed in like 3 hours, but ideally you want to give 2, 3, 4 weeks to a law firm. Marlana Beasley says, I love this channel. Marlana, thank you so much. It's so kind. Tiffany says, Vince, can you represent in state court, trial, or federal? Tiffany, so if we have local counsel, we can do either one, but generally we prefer federal court in most jurisdictions. And it also depends. Like if you're in New York, we can do any court you like. If you're in, I don't know, Utah, we hire local counsel to work with us so our attorneys can represent you in state or federal court. Amy says, and joining. Yeah, I'm not, listen, dude, I'm not, or ma'am, I'm not writing your motion to add an employer. You got to check with local counsel. Exec Monster says, "Hi Vince, I want to know if the arbitrators are required to maintain records of their hearings. If so, how far back?" I mean, I'll say that I maintain records of all of mine, but I don't know if that's required. And generally, retention of records is usually 5 years in my experience, but it could be different in every jurisdiction. So, and also this rule might change from jurisdiction to jurisdiction. So be aware of that. Check with local counsel. Christopher Charles says, "How does the intake process work?" Christopher, are you asking about the intake with our firm? Essentially, you call a call center, and an experienced bilingual individual will have a conversation with you about your case, and they will then say, "Okay, thank you so much. We're going to get this up the chain to an even more experienced intake professional, and they might be in touch with you. They will reach out if there's something further to talk about." And then they do that. They take whatever that initial conversation was and they package it up for a more experienced, more senior intake professional. And that more senior intake professional has kind of like a pretty good command of the elements and the laws and what kind of case we're looking for. We'll generally reach out and have a conversation with you and determine, hey, is this person going to receive, a free half hour of attorney time or not? And then if the answer is yes, then they schedule you a call with one of our attorneys, and one of our attorneys will have a call with you for half an hour. If they need more time, they can give you more time, schedule additional calls or just go long, whatever it is. And eventually they will either make you an offer or not make you an offer of representation. Sonia Underwood says, "Once the CHRO releases jurisdiction, you find relevant information. Can you go back?" Sonia, I don't know off the top of my head. I'm sorry. I'm not positive. Christopher Charles says, "And by the way, thank you for taking time out of your day to help us. It's so hard to talk to an attorney unless you have $100 an hour." Christopher Charles, I'll be honest, it's $1,160 per hour here. So I am more than thrilled to not charge you. I'm just doing a quick. Listen, we don't generally work on an hourly basis. We generally work for our percentage. We prefer to win our money, frankly. But that being said, I would not want to charge you, right? At all. I have no desire to charge anyone. Oh, Amy, you didn't upset me at all. I'm sorry. I just saw you. I can't write a motion for you. Like, I'm not going to be able to guide you on like a state court motion in California. I'm not capable or allowed. What do we have? Christopher Davis says, "What if the racial comments that were made weren't made directly towards you, but because you already filed a complaint with your HR for racial discrimination once, then your direct manager laughs, make light of the racial comments made?" Yeah, it sounds like it could be retaliation. It sounds like it could be doubling down on the racial. Also, like if the racial comments are about your protected class, even if they're not made at you, they're still kind of made about you, right? Like, that's a reality. Like if people are walking around being like, "Oh, I can't stand," I don't know, we'll pick a fake pinkies like Vince, the pink people, right? And they're like, "Well, Vince, you're one of the good ones, but Steve over there is pink too, and we hate pinkies." Okay, well, I'm pretty pink, so you hate pinkies. I don't know if it's that great. You think I'm one of the good pinkies? Like it just sounds like you kind of are saying that because I'm right here right now, right? So like that's still a claim to my mind. Sean S, always great advice, Vince. Thanks, my pleasure. Sonia Underwood encouraging y'all to hit the like button. It does, for what it's worth, hitting the like button really helps us with the algorithm. So thank you very much. You didn't, again, Amy, you didn't upset me. I'm so sorry you thought that. My fault. Kelsey says, "Under what circumstances can the discovery process be extended past its original deadline?" So Kelsey, in most jurisdictions, discovery can be extended for a variety of reasons, including we just didn't get it done in time. It's hard to schedule depositions, Judge. Sorry, we got people coming from all over the country, or we got a lot of depositions to do, or defendant produced 600,000 documents. So we need some time. Like there's a lot of reasons. Kipper Boy says, "What's the average cost to depose someone? Is it common for defense counsel to not disclose who they intend to depose when asked?" It depends on when you're asking you. If you're asking them who they intend to depose during discovery, then no, it is not common at all because they need to tell you who they want to depose so it can be scheduled. If you're asking them at mediation who they intend to depose, they're going to tell you to go fuck off because they're not going to tell you now because why would they forecast their strategy, right? What's the average cost to depose someone? I mean, in terms of so it changes because you can have videographers, you can have court reporters, you might have telephonic suites set up. You might bring in special deposition counsel who specializes in deposition work. You might have translators, right? It's always different. But generally a deposition costs our firm a couple $1,000s would be, not including attorney time. Just the expenses are a couple thousand. Tiffany, Vince, I love this channel. I'm so glad. It's been the most helpful on YouTube. I'm really glad as well. You're making a difference in this channel. Oh, thank you. Thank you, Tiffany, for saying that. Exec Monster X says, how often do you have these question and answer sessions? When I have time. So like I had a free hour today and I tried to eat my lunch and then I ran out of time and I did a live stream. Is it okay to stick it to the man? Give me a thumbs up. Sonia Underwood said, is gaslighting against the law? It can be. If you're gaslighting tied to workplace discrimination or workplace sexual harassment, or I guess in a variety of other circumstances, it could be. But is gaslighting in and of itself illegal? No, and I'm not even really clear on the definition of what gaslighting is. Like, gaslighting as it's used in like social media and by like the wokosphere is an incredibly broad term that like sometimes seems to mean saying things people don't like or that people don't fully agree with. But yeah, listen, if they're like what I would consider like real gaslighting is going on and it's tied to like discrimination or sexual harassment or retaliation, yeah, absolutely, it's part of the case. You can always happy to help. Christopher Davis, any recommendations for consultation fees? Don't pay them. I feel like so many attorneys don't only take my money for the fee when they know they're unable to assist me completely. Yeah, Christopher Davis, we have a lot of videos on the channel. I think 3 or 4 about not paying for consultations. So like your case is an opportunity for us, right? I mean, very much so. Your case, like I actually was talking to somebody earlier today where I said like, because the person I was talking to had paid for some consultation fees and kind of passed the comment like, I think it was like, well, you're one of the bigger firms and you don't charge consultation fees. Why not? And I was like, oh, because I kind of determined your case, like in this conversation was worth money. And if I can then help you win that case, I get money, right? Like, so if I win somebody, you know, I think I used the example like $300,000, like that's probably 120 grand in my pocket. Cool. I'm glad I did that free consultation. Like why would I be charging a consultation fee to hear about a case? Like, does a farmer charge his fields for him to show up and look at them? No. He gets out there and gets to work. It doesn't make any sense. Like, why would I charge you to bring a case to me? You know, I mean, a contractor doesn't charge to go look at your house and say, oh, it's going to cost you this much to put a new roof on, right? I'll tell you why, because he wants you to pay him to put the roof on. So he's going to look and be like, it's this much. You want to hire me? Why pay for a consultation? I don't understand why you'd pay for a consultation fee. Marlana Beasley says $11.60 an hour. Lol. Dang. Laughy face. I know. I'm sorry. It's wild how things have gone and how expensive we've gotten. And that's part of why I started the YouTube channel, because like we did grow expensive and it's not how I started out. But like I can't hire enough people to run cases the way I want that I can just take all the cases I want to take. So we ended up just getting more expensive. So Jim, hi, Vince. Thank you for all the great information you are so freely sharing. My pleasure. In our discrimination case, the primary bad actor executive has left the company. How could this affect our case? Well, it's tremendous for you because potentially they might not be able to get that bad actor to show up to testify now that she or he has left the company. So you might be testifying unopposed, at least by the main bad actor. And I love that for you. That is tremendous. Jet says, thanks, Vince. You've been a big help these last few years. I'm really glad, Jets. Also, I'm sorry about your football team. As a Bills fan, I can't say that I want good things for you, but I am sorry. Although maybe Aaron Rodgers will shake the rust off. I mean, he's a talented guy. It's just been a while since he played, right? YouTube user Wendy Connell says, I'm in the discovery phase in an EEOC case. It's so painful and no attorney wants to help me until it's a civil case. Why? So Wendy, I have videos on this. I hate when attorneys refuse to handle EEOC cases. Specifically at our firm, we actually seek to take cases at the EEOC level so we can begin to add value and reduce risk from the outset. So it just doesn't make sense, to my mind, to have a case go all the way through the EEOC without the intercession of an attorney who would be safeguarding the value of that case, right? Okay, I just heard a message here. All right. Oh my God, so many emails. So many emails. Oh my goodness. It's going to be a short live stream, y'all. Okay. Amy says, I've received a settlement offer of $4,000. Is this even worth it? And should I bother with a counter demand? Listen, I think having a conversation about people giving you money is always worth your time. So yeah, extend your counter. It's not like it takes you so many hours to tell them, like, I'm not going to take $4,000, but I would take X amount of dollars, right? Sonia Underwood is again encouraging you to hit the like button, everybody. Thank you so much. All the way. By the way, we have 54 concurrent people at 2 p.m. Eastern time on a Thursday. That's pretty wild. That's great. My baby girl P says, what would an attorney intake person want to know? Why would an attorney intake person want to know who lives with you? I don't see any reason why an attorney intake person in the field of employment law would want to know who lives with you. If you're dealing with like divorce or a divorce action or like a landlord tenant case, something like that, maybe. But I don't see any reason why somebody in our field would want to know who lives with you. YouTube user Anish says, what if the key witness left the company, the HR guy who terminated me? What if none of the main witnesses speak? Is it your main witness or their main witness? Sounds like it would be their main witness since it's the person who terminated you. So if they left the company, that's good for you. Craig Adams says, I have a discrimination claim against my employer. I'm sorry to hear that, but I hope it's valuable. They purposely did not notify me that I came in contact with a coworker who was positive for COVID. Could it be retaliation if they purposely did? I mean, if you're able to show that they purposely tried to expose you to COVID because you engaged in protected activity, that is a retaliation claim. That might be hard to show, but certainly it could be if you can show it. Nabil Asadullah says, so I was told on a job interview with a billion-dollar company that I essentially wasn't going to be hired for a call center job because I'm in a wheelchair. So far, no response to EEOC charge. That sounds like a hell of a case. I hope you get paid big money. Avatar of Justice says, quadruple heart emoji. Why is it so hard for physically disabled people to obtain even simple accommodation with doctor's notes? Any suggestions? I would actually say it is generally easier for physical disabilities to receive accommodations in the workplace. Mental disabilities actually create more problems for accommodations in my experience, but it's still not easy. I know that, and I don't know why. My story is still being written says, yes, the person who terminated me from HR no longer with the company. This person just left several months ago. It makes me wonder why she left. Who knows? But if they're gone and they can't testify against you, that's potentially useful. YouTube user Philip Morningwood. Hi, Vince. How many people is it useful to try to split using 1981, 1983? Is some number too many? I don't understand. Split how? Nabil Asadullah says, just to go back to Nabil's earlier. So Nabil was told flat out, you're not going to get a job at a call center because you're in a wheelchair, I think. And Nabil is now saying that they have that on recording, but attorneys still won't take on that contingency. That's wild to me. That sounds like a great case. Sean S. says, gaslighting seems to be the new replacement word for antagonizing, in my opinion. It softens the meaning. Unacceptable. It's disgusting how employers hide behind semantics. Prove discrimination. Tough. Yeah, can be. Sean S., my rhetorical statement. Christopher Davis, the EEOC treated me like dirt the first time. The exchange almost broke me emotionally. However, I recently contemplated filing again because I'm limited on options. Can you file a suit against the EEOC? Sure, you can file a case against the EEOC if you want. Kamika wins. I mean, this just Christopher Davis. This is America, right? We can sue anyone. Kamika wins. I told my HR director, and also Christopher Davis, I would not take the case against the EEOC. I only take cases against employers, for the record. But yes, you can potentially sue them. Kamika wins says, I told my HR director and immediate boss I felt as if she was discriminating against me and treating me unfairly, not like how she does the other supervisors. Will this qualify for national origin discrimination? Potentially, yes. Sonia Underwood says, we want you to get paid. Yes, I do want you to get paid. I very much want you all to get paid. I want you to get big cases and get made whole for what was done to you. Okay, we got about 7 minutes left. I might not get to all these questions. 7 minutes left. 7 minutes. I'm so sorry. I only have an hour today. Harlem World Baby says, I will be driving through Harlem tonight. EEOC had my case in investigation for over 3 years. That is not so surprising. The EEOC can take a long time, especially if you're not represented. The EEOC closed on one of the cases. I reached out for settlement agreement with the company through the EEOC. 3 years ago, mediation, they offered me $21,000. I just reached out to see what my offer will be now. The most they are now going to offer me through the EEOC is $15,600. So I don't know if it's 15,000. I guess it's 15,600 the way you wrote it. I'm sorry to hear that. I don't think anything about it. I don't know why it went up. I don't know why it went down. I don't know anything about the case, so I can't say anything about it. Anish, it's their okay. This is about the witness that left. Anish, it's their witness. Does my employer have to accommodate when I have ADD and they failed to accommodate when I asked them to then terminated after complaining? Yeah, so that sounds like a failure to accommodate claim and a potential retaliation claim. Kelsey says, can you depose an important bad actor even if they haven't left the company over a year ago? Sure. Yes. Will they, I mean, if you can get jurisdiction over them and get them in for a deposition, yes. Will they still be represented by the company's defense counsel? Don't know. Up for question. I mean, the defense counsel would want to, but they might not accept it. Or will they have to retain their own counsel? So they don't actually have to retain any counsel. They can just go in and be deposed. But if they want counsel, they are, in most jurisdictions, to my knowledge, able to hire their own counsel, or they could let the employer provide them counsel. Diesel says, hey, I took the LSAT and got a 154 with no studying. That makes sense to me. Also, I was curious if you knew of a way to go to law school without becoming broke and miserable. Is it possible in the United States? Yeah. So I think there's like some public law schools, like for instance, Buffalo Law School. It's a state school. So if you establish residency in New York State, you go to Buffalo Law School. I mean, I don't know what it is now, but at one time it was like $6,000 a semester. So you can get through law school for like conceivably $36,000. Which, is not nothing, but is not going to break you the bank necessarily. Also, you can get a scholarship, Diesel, right? I mean, you seem like a clever fella. I would presume you might qualify for a scholarship. Okay, 4 minutes to go. 4 minutes to go. Nabil says, so I have been scouring for an attorney for my case, and you're right, the recording is really bad, but evidently Kentucky has crappy employment lawyers. Nabil, consider talking to national firms. If you're not finding a good attorney in Kentucky, talk to the national firms. And again, I'm not vouching for anyone, but like there's a bunch of them. Morgan & Morgan, Gloria Allred. There's a guy out of Southern California. Shigarian, maybe? Our firm, right? Like, and I'm not saying hire our firm. I'm just saying like talking to the national firms if you don't have good options locally. That's why the national firms exist. In a lot of this country, there are not good options for employment attorneys. So like people hire national firms, but national firms tend to be more expensive. So it's because they got to move stuff around the country, right? George Culver says, I have my EEOC mediation meeting on September 23rd. Good luck. I am not currently being represented by an attorney. Don't love that for you. Do you have any resources to calculate compensatory and punitive damages? We sure do. We have a playlist. We have a playlist that helps you calculate your damages. It's called the Damages Calculation Playlist on the channel. I hope it helps. It's got many videos in it and talks around the topic as simply as we can without getting into the nitty gritty. Amy, my pleasure. Amy says, thank you kindly for everything. My pleasure. Okay, 3 minutes to go. Christopher Davis says, can a company still terminate you during or after a settlement? I mean, listen, it's illegal to murder someone, but people still can do it, right? Like people do things that they shouldn't do all the time. So can they terminate you in the middle of a settlement? A terrible idea for them if they're subject to a potential retaliation claim, but they can. They also can do it if you did something bad. Like if you have a completely valid case going, but you go in and like elbow the supervisor in the face tomorrow, guess what? Your ass is getting fired. And no one's going to think it's retaliation. Everybody's going to think you're just an asshole. You might still have a valid claim for the other stuff, but the retaliation claim is going to be shot because you're like not going to have much success proving like that wasn't a good termination. It was a great termination. You elbowed somebody in the face, right? Okay. I got 2 minutes to go. 2 minutes to go. Oh. Chat is blowing up. 2 minutes to go. I'm not going to get to all these questions. I'm just going to be upfront about this. Okay. BZ says, will you explain what the difference is between a civil lawsuit, and an EEOC case? Should I wait until the EEOC case is done? All right. If you want to file a civil lawsuit for workplace discrimination, workplace sexual harassment in federal court, generally speaking, you'll need a right to sue letter from the EEOC. So the EEOC is a precursor. It's a required thing you must do to use the laws that go through the EEOC and use them in federal court. You want those laws. Those laws are advantageous. Listen, there's other laws. You can look at 1981 claims and stuff like that. You can look at state laws and local laws. So there's other laws you can use, but generally you don't want to leave any laws behind. So if you're going to file in federal court, you want to generally, for those claims, bring the cases that went through the EEOC, get the right to sue letter, and file. So that is the difference between the EEOC and a civil lawsuit in federal court. You can also, just worth noting, file in state court with state court claims that don't need to go through the EEOC at all. But you then don't have the advantage of the federal laws, which you may want, depending on what jurisdiction you're in and what the laws are where you are. YouTube user Diesel says, why does my former employer maintain the employment of my former manager when they essentially had to pay out obscene amounts of money? I don't get it. I don't know, Diesel. They might think that person didn't do anything wrong. They might think that that person is valuable enough that it's worth paying. They might have some issue where they can't fire that person because that person has their own case. I don't know. Kamika Wins says, can you take cases in Georgia? So we take workplace discrimination and workplace sexual harassment cases in Georgia. That is it. However, I will note to you that there are good local attorneys in Atlanta, Georgia. I know of a couple. They're going to be cheaper than us. So it's worth having a conversation with them first. What do we got? Last question. 3 o'clock, last question. Harlem World Baby says, are employment law firms for the plaintiff afraid when a company is represented by a top employment defense firm? No. Almost every big company is represented by a top employment defense firm. There's like really only 10, maybe 20 big employment defense firms that are large enough to defend large corporations. So we always see the same defense counsel. People will call us up and be like, oh, they got Quinn Emanuel on the other side, or it's Fox Rothschild or Nixon Peabody. And like, I don't know if you can go toe to toe with Nixon Peabody. And you're like, okay. So here's the deal. We got about 450 cases a year, and Nixon Peabody's counsel on 40 to 60 of them. So not concerned, right? Like, it's just not an issue. And that's going to be true for almost, like, and I'm not tooting our own horn. Like, that's going to be true for almost any employment law firm. There's not really a firm that exists where an employer could throw more money to get better employment defense counsel. Employment defense counsel is already super expensive. And within the top 20, generally, they're all good. Is there some variance? Are certain individuals like, yeah, there's some idiots. Like I can think of like some partners in employment defense firms who are wildly incompetent, but like they're bolstered by their associates. They're not allowed to like do things that would hurt their clients. The attorneys around them will be like, oh yeah, Michael Webster, shh. Enough. We're gonna take care of it. You just go bring the cases in, and enough with the talkie. Don't talk to opposing counsel. You're a moron, and everyone knows it. I'm like, I shouldn't have used that gentleman's name. That's a fictional person. Oh, okay. Last question. Diesel says, will going to a small law school that isn't a brand name like Stanford or Yale, etc., be an issue for your future career prospects? Diesel, if you're looking to go into employment plaintiff side law, no. Doesn't matter at all. Better schools generally do not produce many plaintiff side attorneys. If you're looking to be a judge or a law school professor, or even in some cases a big law attorney, if you go to a law school outside the top 20, maybe outside the top 50. So for like judge or law school professor, you got to be in the top 20 law schools. Big law, I'd suggest being in the top 50 law schools. And like mid-sized defense firms, top 100 law schools. But beyond that, no, not at all. All right. All right. I can't answer any more questions. But everyone, I hope you're having a wonderful day. I hope I was helpful in some way. Like, subscribe, all the things helps the channel. I wish you all really well, and I will try to do another law stream. I might actually do another law stream tomorrow afternoon. I had a couple of things free up this, and I like doing the live streams. Seems like it helps people. Seems like people value it, so I'm going to keep trying. All right, take care, everybody. Bye.